Welcome everybody to Law and Crime Daily. I'm Jesse Weber. What seemed to many people to be just an open and shut case is now turning into a daily waiting game. The jury determining whether 3 co-defendants killed rapper XXXTentacion has passed 24 hours of deliberation. XXXTentacion's real name was Jahseh Onfroy. As we reported in 2018, he was shot to death and robbed while leaving a Florida motorcycle dealership. Prosecutors point the finger at 3 co-defendants, naming Michael Boatwright as the triggerman, Trayvon Newsome as the second gunman, and Dedrick Williams as the ringleader and getaway driver. The star witness was another co-defendant, Robert Allen, who pleaded guilty to second-degree murder and robbery charges. He testified against his alleged accomplices. Now, some of our viewers at home have suggested that the jury might be tripped up by the fact that the star witness is a criminal and a snitch. So we asked an attorney who practices in Broward County what he thinks about that.
Snitch dramas are one of my favorite part of criminal trials, okay? And, you know, it can go either way because on the one hand, a snitch is always paid for their testimony. These prosecutors try to get out of it every time, but the reality is that guy's on the stand telling you this story because he's getting some kind of benefit. And the benefit we know he's getting is freedom. He got a lesser sanction, he's getting less time in prison, a lesser charge, whatever the case may be, he's being paid for his testimony. But on the other hand, that doesn't mean it's necessarily false. Because remember, the government is paying for cooperation, not necessarily testimony. And I know that's a very fine line to walk, but here's the net result, and that's really what matters. Juries convict on snitch testimony. That's just the bottom line.
Who doesn't like a good snitch trial? I'm here right now with my co-host, legal analyst Brian Buckmeyer, Terry Austin. So Brian, Robert Allen, let's talk about him for a second. So he testified to lower his jail time, but could the jury deliberating for such a long period of time, or the eventual verdict, could that affect his deal with prosecutors?
Absolutely, Jesse. It all depends on the details of this agreement. Oftentimes, prosecutors will cut this deal of reducing your jail sentence based on the outcome or the efficiency of your testimony. So if he testifies and a jury is deliberating for 24 hours and ultimately comes up with, I don't know, hung juries across the board, acquittals, anything but a guilty verdict, the prosecution, depending on their agreement, may be able to turn around and say, hey, you didn't benefit us to the degree that we wanted, and maybe you're not going to get the extent of the agreement that we said we would give you. So he's definitely sitting there thinking, I hope he comes back with a guilty verdict for all 3.
Well, Terry, do you think it's a possibility that one or more of the defendants might be found not guilty, and if so, who?
Well, at this point, I do think that's a distinct possibility. If they're involved, they should all be responsible. Under the law, that is what is supposed to happen. But here, they might be looking at Williams and saying, look, he drove the car, and we know he cased the joint because he was on the video, but perhaps they didn't think he was really involved and didn't know what was going to happen. I think as far as Newsome is concerned, he too could probably get away with it. He was the second gunman, but he didn't shoot. And then the worst, I think, as far as a not guilty, I don't think it'll ever happen, but we'll see. Newsome is because, or rather, the third Boatwright, he was the shooter. And so I do think if we have a guilty verdict, it'll come back onto Boatwright because he was the one who actually took the matters into his own hands and he actually shot XXX. So
who would have thought that this trial would have had a longer deliberation process than Alec Murdaugh, but we're always in for surprises. We do have an update, though, for you right now on the University of Idaho and the process of healing the community that it's undergoing. So the state's governor, Brad Little, made good on his promise to provide the Moscow Police Department with $1 million to cover costs of the investigation. But lawmakers have also approved another $1 million in state funds for the university itself. That money is going to cover things like increased security, shuttle service, counseling, and a vigil. Now, we know that 4 University of Idaho students were found dead inside a home just off campus on the morning of November 13th. They were stabbed to death. The suspect, Brian Kohberger, was arrested around 6 weeks later. He was a doctoral student at nearby Washington State University. Kohberger was arrested over the Christmas break in Pennsylvania, where he was staying with his parents, and is now in Idaho awaiting trial. The mother of a teen who fell from the world's tallest tower drop ride and died has reached a settlement with the Florida amusement park where it happened. 14-year-old Tyree Sampson slipped out of his seat on the free fall ride at Icon Park almost 1 year ago. He fell from more than 100 feet to his death, this according to the lawsuit. Now, the Missouri teen was a football player visiting the park with his team during spring break. A forensic report determined that the person overseeing the ride that day made adjustments to the harness to accommodate the teen, who weighed more than 300 pounds. The owner of the ride, which operates separately from the park, decided to take it down after Sampson's death. Attorneys involved in the lawsuit haven't released details on the settlement terms. Well, we have another celebrity civil trial on our radar, this time out of Utah. Actress and businesswoman Gwyneth Paltrow is being sued over an apparent skiing collision that left one man seriously hurt. Retired eye doctor Terry Sanderson filed the lawsuit in 2019. The now 76-year-old claims that he and Paltrow were going down the same slope at Deer Valley Resort in Utah when Paltrow, who he described as, quote, out of control, collided with Sanderson from behind. Sanderson says that the collision gave him a brain injury, 4 broken ribs, other serious injuries. He originally wanted over $3 million in damages, but a judge rejected his emotional distress claim and said that that wasn't a hit-and-run accident. Sanderson is now asking for over $300,000 on a negligence claim, but Paltrow isn't going down without a fight. You see, she's countersuing Sanderson, claiming that he actually crashed into her. She says that Sanderson even apologized to her following the collision, and she had to cut her skiing trip short due to minor injuries. Her countersuit is asking for exactly $1. That's right, $1 in compensatory damages, along with, of course, her legal fees and expenses. The trial is slated to start on Monday. So, Brian, negligence laws, they work very differently in every state. What did we learn about what's happening in Utah? Okay, Brian, I think we have you muted, so we're going to get back to you. Terry, I'll go to you real quick. So the judge dismissed the intentional infliction of emotional distress claim against Paltrow. That seemed like the right decision, right?
It was definitely the right decision. This was in a summary judgment motion, and in order to get that intentional infliction of emotional distress, you have to have an intentional or reckless act. The judge said nothing that he heard based on the facts in this case said it was intentional, and that conduct has to be extreme. The conduct was not extreme, and it has to have caused that emotional distress. So you have to have all of those elements or you don't get that cause of action, and a judge rightly dismissed it.
Okay, so Brian, back to you. We've got about 30 seconds. Negligence in Utah, what should we know?
Modified contributory negligence, meaning that if you are found to have more than 50% of being negligent and you can't recover. So if the other person, thinking of it that way, is more than 50%, then the percentage in which the party at fault is, so if they're 30% at fault, that's how much you can recoup. It is a whole mathematical equation. So if I'm negligent towards you, Jesse, and I'm more than 50%, yeah, I can't make that suit and get that money. But if you're 80% and I'm only 20, then I'm in the win, but my 20% gets subtracted.
So the only difference I'll say is it's different than a car accident, because I think it all determines on a ski slope who was downhill. It might be that 2 people can't both be at fault, maybe just one is. But hey, I'm no skiing crime expert, so we'll wait, civil law expert. We'll have to see this way this goes.